Are live, and we've got, man, do we have a show, ladies and gentlemen? Do we have arguably the funniest thing that could have come out of the Critical K shit show active right now? Uh, I mean, I figured this was going to be the end result. The default judgment has been granted, so we'll get that out of the way. I'm not going to clickbait. Oh, you'll never guess what happened. No, the default judgment was granted. I kind of had a feeling that was going to happen after her bullshit last month. I even said as much. I didn't think it would happen after the October hearing. I was correct on that, but after uh, she didn't show up last month for the hearing, then I said, yeah, it's probably going to be granted now. She's swung three times and she's missed three times. She has not shown up to three different meetings that were ordered by the court, one of them telephonically, two of them in person. Here we are. Here we are. We've got this dumb bitch who decided that she was just going to ignore the court to tell the court that it was it was it's not going to happen. She wasn't going to show up. And here we fucking are. We're here because of her refusal to be present for the hearings. And so we're going to be taking a look at this. We're going to be taking a look at what brought us to this. Who is she? The initial complaint. We're going to take a look at some of that. We're going to take a look at some of her response to the complaint. We're going to take a look at first at her response that she filed that was just ignored. It was absolutely ignored, and you'll see why when I bring it up. And then we'll actually take a look at the judge's order granting the default judgment. So let's hop right into it, ladies and gentlemen. So here we have, excuse me, I actually have to share screen, and I'm gonna share this. Boom. All right, so let's actually go down here. So the first thing we're going to be taking a look at is this response that she filed. Oops, did not mean to do that. Is this response that she filed on March 28th? This came after the court sanctioned her $900 for telling the court to fuck off for the second time. Okay, this is also after the third hearing, right? The third hearing that she ignored, that she didn't attend because we knew she wasn't going to. The court had gone out of its way to make it very clear to her, hey, you show up to this, you're not giving away your the claims that you have made, that you are not subject to our jurisdiction. You've already preserved them. In fact, this fucking hearing is for you to make your case as to why we should look at our previous decision as to why we have jurisdiction, right? That's what this hearing is. This hearing is specifically to handle that. And she said, "Yeah, nah, man, nah, I'm good. I don't I'm not going to. I'm just not going to show up." So after that hearing, her motions, her outstanding motions, was like a motion for summary judgment, motion to dismiss for lack of jurisdiction, and something else. I can't remember what it was off the top of my head. They were denied outright because she wasn't there. They were denied as abandoned. And the only thing left over from that was the motion for default judgment filed by what's her name? By Rae Andreacchio. And I you know what, if I need to pull that up. So have to. This is the motion for default judgment. All right. Because I forgot to pull that up. Also, I'm now looking at the tab and seeing default. That's not how I spell default. I am dumb. Admonish. Anyways, so the first thing we're going to take a look at is her response to the sanctions for $900. And there's really nothing to go over. She basically literally copies and pastes from previous filings that she had done. And this is why it was fucking ignored. You ready? You ready? Look at this. Like, she didn't even take the time to go through and make sure that all of this was the exact same font or the exact same size. 100 fucking percent. It was ignored outright because of this. You can't do this, right? It shows you how much she actually gave a shit about this case. She didn't care, right? She's made that very clear in her filings. She's not taking it seriously. She thinks this is vexatious. She thinks this is frivolous. She thinks Rae is a vexatious litigant, and she's not taking it seriously. And she thinks that the court should have dismissed it because of that. Cynic in Chief says Chapter 7K is screwed. What happens if she refuses to show up to a post-judgment deposition? She doesn't have to show up to a post-judgment deposition as far as I know. The only thing that the court has said right now is that there is a scheduling, or there is an evidentiary hearing May 22nd. I think it's May 22nd. She is invited to attend, but she's not required to be there. So who knows? Who the fuck knows at this point, right? So let's go over this, right? Hey, Calming, how are you? So let's go over this. Let's talk about it. Who is Critical K? Marie Yax, I am not doxing her. This is part of the public filings. Is a true crime YouTuber, right? I'm actually gonna take these off. I don't need these on, and I'm not gonna have them on. They're really good. They're really good headphones, but they're a little tight. I had to buy new headphones, but they're a little tight, and they're noise canceling, so it's really weird. Anyways, Critical K is a true crime YouTuber, meaning she is near 50. She has nothing going on for her at home, and she talks about cases, generally cases that are male on female, generally violent crimes committed against women by men. And it's always, well, not always, but majority of the time it is the man is always wrong. The woman, it's always some bullshit. I don't want to say feminist because it's not feminism, but it's some bullshit thing that she and her ilk do, where they are defending women. That's what they claim. In reality, she's just a misandrist. I think it's misandrist, right? She just hates men. She hates men. Now, I say most of the time they are on the woman's side, and I say most of the time because there is a case, the murder of Shannon Watts and her daughters, by Chris Watts, her husband. Now, during that entire fiasco, Kay is sitting there making jokes about how, Shannon deserved it, or Shannon's the one who actually killed them. She made light of the fact that she was found in a hole in the ground. In fact, one of the things that Kay loved to say was she was found face down and ass up with her daughters in a hole in the ground. And she just cackled like the hag she was as she said this. She never believed that Chris Watts killed her and her daughters, right? Because she was lusty after Chris Watts' dick. That's basically what it boils down to. And then when it came out that Chris Watts actually did it and he was convicted, then she comes out with a mea culpa. I'm so sorry. I see now I was so willing to rush to judgment and blame Shannon for what happened and how it was actually Chris Watts. I didn't want to believe it was Chris Watts because he's just so dreamy and shit like that. But she was just a piece of shit during that. And she's gotten to other cases, most notably the Sophie Long case. The Sophie Long case was a case that was kind of captured the national spotlight for a bit, where Sophie Long, this adolescent girl, is recorded screaming at her grandmother. She doesn't want to go with her mother because it's a visitation thing, right? She just had visitation with her father. Her father's giving her up to go back to her mother, and she's losing her fucking mind because allegedly the stepfather, Jacob Bellington, had been sexually assaulting her. And it blew up, and it became this, it became this cause célèbre for male rights activists and fathers' rights activists, and all this drama associated with it. And during this, Michael Long is having, he can't talk about the case anytime he tries to. All these screeching hags like Squishy the Cat and Lisa, something. I can't remember what her name is off the top of my head. But Lisa and, Kaylee with a T and Critical K would come out of the woodwork to screech like hags and try to shut down any conversation on it that wasn't pro Kelly Long, the mother, because all these hags are brought in by Red Banyan, the PR firm that she hired for the case. And like the piece of shit that she is, at the time before that she had been brought in, right? Before she had been brought in, I believe, I can have Kiwi Farms Ken Jennings confirm this. I may be a little off on the, what's it called? On the, what's it called? Timeline. There we go. Yeah, Lisa Sadowski. There you go. Thank you, Twisted. But before that, she and her followers on Patreon, I believe in a Patreon chat, were making inappropriate jokes about a child who was allegedly sexually assaulted. And they were posting GIFs of rubbing a finger along a split chicken breast, and split chicken breast looking like, a little child's intimate areas, shall we say, which is really funny insofar as Kay has gone after myself, Nick Ricada, and Kiwi Farms Ken Jennings for talking about a little girl's sexual assault, examination. But she and her friends can post shit like that and make fun of a little girl who was allegedly sexually assaulted. It's kind of funny how that works out. Now, Kay and her friends, when Kiwi Farms Ken Jennings was going to talk about the writ of mandamus that Michael Long had filed, he was going to talk about it. And one of the lawyers for Kelly Long, Lisa Elkind, sends him a cease and desist. So he doesn't talk about it. Instead, he talks about a couple of other things, right? It comes from specifically, I believe it was the affidavit of Courtney, I don't remember what her last name is, but it was Michael Long's either estranged wife or wife at the time. I don't remember off the top of my head. And what ends up happening is her friends find out Kiwi Farms Ken Jennings' name, where he lives and where he works. And Lisa Sadowski specifically calls him up. That's why I had her phone number. And he doesn't answer. She calls him twice, actually. The first time on her her personal phone, and realized, oh shit, that number is not blocked, and then called him a second time with a blocked number. But they went after Kiwi Farms Ken Jennings, actually got him fired. Now, Kay attempted to call where she thought he worked. In fact, during the stream, she's typing, Ken, tell Sarah to put me on with you, because apparently, I guess Sarah is the receptionist, and I guess she's thinking he's at work and streaming from work, and Sarah, the receptionist, is taking the calls like this is some fucking radio station. He's got a call screener. Makes no fucking sense, but this is the two brain cells that Karen has left working overtime to fire some neurons up so that she can actually put together a coherent sentence, right? She's not a smart person. She's absolutely retarded. And she is a drama monger. That's not a joke. Her own child cut off all contact with her because Kay started shit with his girlfriend. Actually made Facebook accounts, allegedly. I have to say allegedly, right? But the allegation that she made Facebook accounts using this girl's name and using this girl's pictures to catfish guys and to cause drama so that she could turn around to her son and go, "Oh, she's just terrible for you. You should have nothing to do with her. You should have nothing to do with her." They ended up getting married, by the way, and he cut off all contact with her. So as much as she loves to go after Alyssa about being a terrible mother, Alyssa appears to be a far better mother than fucking Kay is. Let's put it that way. Her children exist only as a shield against criticism, as something to use as an excuse as to why she can't show up to a hearing. And she did that before. If they don't have a use outside of being something that she can use to go, "I'm a better person than you," she gives zero shits, as evidenced by her oldest son cutting off all contact with her roughly a decade ago. So, there you go. But Kay is such a fucking mongrel that her own friends in the true crime cat lady fucking sphere didn't even pass on Ken Jennings' information to her. So she was calling the wrong person. She was calling the completely wrong person to get him fired because she wanted on to Ken Jennings' show, right? She thinks she's owed that. You have to bring me on. You have to bring me on. Yeah, I'm going to bring this up really quick. So, Calming the Chaos says, "Does Kay have a channel?" Twist replies with, "She made a new one." Yep. And I've linked it in the fucking name for this stream. And yes, she's bandivating. She's bandivating. The funny fucking thing about that is last September when Nick Rekieta had his channel suspended and then was reinstated. But before it was reinstated, Karen actually tried to pull the holier than thou attitude. He just has to accept that he was banned and get over it. Bitch, you've been banned and you have another fucking channel that you stream on. Fuck off with that shit. Fuck off with that shit, bitch. Anyways. So, she is such a mongoloid. She is so useless, other than as a screeching harpy, as a banshee, that her own little friends didn't pass on anything to her. So not only was she trying to get him fired, right? Trying to dox, trying to get him fired, she did so badly, so poorly, that it's just fucking pathetic. It is fucking pathetic. But, ladies and gentlemen, it's okay though, because she's on the right side of history. She's learned, right? No, she hasn't learned. So, Rae Andreacchio is a therapist. And by the way, this needs to be said. Karen hates therapists. I've come to that conclusion. I come to that conclusion because the three people she seems to go so hard at are all actual therapists, all actual counselors, excuse me. Rae Andreacchio, who sued her, is a therapist. Tracy, Calming the Chaos, is a counselor or therapist. I can't remember which. I believe she's a therapist. Kiwi Farms Ken Jennings is a therapist. Kay loves to talk about how she was a therapist for 25 years, which is a fucking lie. The critical K, Marie Yax, was an occupational therapist assistant. Now, what's the difference? Well, first off, schooling. An OTA requires what is essentially an associate's degree, 2 years of college to get an OTA degree, to get the licensure and everything. To be a therapist, is not just a bachelor's degree, it is post-grad stuff. You generally go for a master's, right? You go for a PhD, you might as well just be a fucking psychiatrist at that point, but that is neither here nor there. Okay. So Karen feels incredibly inadequate next to any of these three people because they are actual therapists. When they say, I am a therapist, they're not exaggerating, they're not embellishing, they're telling you it straight. They are therapists. Kay's not a therapist. Kay was an OTA. She was an assistant. Now, you make some decent money as an OTA. I'm not going to deny that, but to say you're a therapist would be the same as me with a bachelor's in psychology who, does some volunteer work at the VA. Me going, yeah, I'm a therapist. I actually have more schooling in terms of a degree than Karen does. I am closer to being a therapist than she is. Okay. So Rae Andreacchio is a woman. She was a therapist, and her son self-harmed. He took his own life. Now, officially, it's been labeled as suicide, right? That's what the official coroner's report is. YouTube overlords. That's what the coroner's report says. It was a suicide. Rae believes it was something else, that it was murder. And she has been fighting for years to get to the bottom of it because she doesn't believe what the coroner says. And so when we get over here, we actually get to this. Now, this is the complaint. And I've highlighted some important parts. I have redacted Kay's address. Look at me being a nice person. I left Matt's address in here because he's a fucking attorney. He doesn't get the benefit. And keep in mind that they are asking for $10 million in damages against Kay. Do I believe they'll get that? We'll go into that at the end of this. So we're going to go down. Now, it's not that Kay says she believes he committed suicide. That's not what she's being sued for. Saying, I believe Ray's son committed suicide, you can't sue over that. That's an opinion. In fact, it's an opinion backed up with a medical examiner's report, a coroner's report. You couldn't sue over it. It's the other things she has said and done that caused Rae Andreacchio to sue her. So in the complaint, I've highlighted some things. During the webcasts, I'm going to actually zoom in once. During her live webcast, meaning her streams, the defendant interviewed Mississippi residents over the telephone about the Christian Andreacchio case. Remember that part. She interviewed over the phone Mississippi residents. Okay. The Calder test right there would give jurisdiction for the court, right? That was part of what made the Calder test the way it is. The Calder test says if you reach into the states, right, if you're sourcing from individuals in the state and you know those people live in the states, you subject yourself to the jurisdiction of that state. Now, there's more attached to it, but for the purposes of this, that right there would probably get you over the hurdle, and in fact, it did. It goes on. She has also conducted in-depth discussions about the official investigation file that were prepared by Mississippi law enforcement personnel, not able to get over the hurdle of jurisdiction. Just because you talk about the case doesn't mean you subject yourself to the jurisdiction. In fact, filing a FOIA for that information would not necessarily put you within that jurisdiction. It's your right to file a FOIA, a Freedom of Information Act request for such things. It doesn't necessarily mean that you subject yourself to that jurisdiction. She also directed messages to the plaintiff personally on her live webcast, such as this one from on or about April 23rd, 2021. Quote, "You're not ignoring me, Rae. You are very well aware of me, and you know what I have taken that I have taken up for Dylan and Whitley, and I am a force to be reckoned with. I am a Powerball. You never met a motherfucker like me, Rae. End quote. Now, really funny that she would say shit like that and then turn around in her filings and go, I'm actually a victim. I'm not a bully. I'm actually a victim. I'm actually a victim. The plaintiff is harassing me. The plaintiff is bullying me. My mental health. Oh my God, I'm going gray. I'm losing more hair than Spectre has. I can't believe it. I'm the bully, even though I've literally done this for everybody else. I did the exact same thing. I'm accusing her of doing. I've done it to other people. Which go fuck yourself, by the way. But she, I hate it. I hate that shit. It pisses me off. Okay. So she's calling up Mississippi residents and she's directing by to the plaintiff by name she knows lives in Mississippi. I said Mississippi, not Missouri, right? Really hope I said Mississippi. Anyways, so we keep going. Relevant facts. On or about March 21st, defendant interviewed Dylan Swearingen about the events leading up to the death of Christian Andreacchio. Mr. Swearingen is one of the last people to have seen Christian Andreacchio alive. So, she called him up. She was talking to him. I think she was talking to Whitley, who's another person who saw Christian alive. Don't know, but I know that Dylan was definitely there. During that webcast, the defendant made the following statement about the plaintiff. The first thing I want to say is if Rae wants to try this case on social media, as she has attempted to do since 2017, I'm happy to oblige her, right? I'm happy to oblige her. And until now, she has really dominated the narrative about this case via intimidation, bullying, and outright lies. And I sort of set the groundwork for that the other night. And I'm going to continue to lay that groundwork and continue to provide proof of the things that I claim that she has attempted to control the narrative via intimidation, bullying, lies, bribery, getting people drunk, getting young people drunk, etc., etc. And that is very troubling to me, but she has truly dominated the narrative, her and her family, her brother and her children. And it's time for the other side to have their say. It's time for the other side to have someone who takes up the mantle for them. So this is the important thing, right? She's alleging bribery and getting young people drunk. Both crimes. Bribery is a crime. Getting young people drunk, buying alcohol for minors is a crime. So, she's accused her of two crimes. By the way, she never provided any of this evidence. I just want to make that very clear. She has not provided this evidence. On or about April 11, 2021, defendant interviewed Dylan Swearingen again along with Matt Miller. Mr. Miller also lives in Mississippi. Upon information believed, this call was made from Mississippi. These are the relevant parts of the colloquy. Wasn't Hayes Mitchell, who is an individual who was a patient of Rae Andreacchio's, he ended up self-harming, self-deleting, if you will, as well. Wasn't Hayes also treated by Rae? Matt Miller, I don't know that. I don't know that. Defendant, defendant is critical K. Dylan, was Hayes treated by Rae? Dylan, we know you were. Dylan Swearingen. I was told through someone else at some time, which, that helps you just tells you what you should probably know. But anyways, excuse me. I'm not 100% sure, so I can't vouch for it. But I'm sure that there is somebody in my group that, if this is true, can vouch for it. Matt Miller says, yep. Kay says, it seems to me that is something that I have heard. So she's saying that she's heard it from somebody else. It seems to me that this is something that I have heard, that Hayes Mitchell was also treated by Rae, and that is what I need people to understand. There is a whole host of young people here, specifically teenagers and young adults, who have been treated by Rae in this community via her workplace. They have been treated. They have been treated both counseling wise and medically by Rae. Really? Because I'm pretty sure Rae is only a therapist. Rae can't issue, she can't prescribe medication. Therapists can't prescribe medication. The only mental health professional that can do that is a psychiatrist. That's why they're actually doctors. Psychologists, not doctors. Therapists, not doctors. Counselors, not doctors. They can't, and if she was an actual therapist, by the way, right? If Kay was a real therapist, she would have known that. She would have known that. Man, that should be part of your, Tracy, correct me if I'm wrong. Can you prescribe medication? I'm pretty sure you can't. Pretty sure you can't. You don't have a medical degree. Correct me if I'm wrong. Anyways, and some of these people who have been treated by her counseling wise and medically have gone on to be accused by her of being involved in this. This is how far her reach goes. I really do believe that Hayes was treated by, now this is a break. That means that it's kind of like an ellipses. So there was things between this. Kay says, I really do believe that Hayes was treated by Rae, and Hayes is now dead with a drug overdose, and he was treated by Rae. Again, another break. He's dead also by self-harm. So she has a son that is dead by self-harm, and she has a patient who is also dead by self-harm. Well, objectively, and this is before I knew about any of this shit, when I first saw that, I was like, yeah, she's trying to put these two things together. Her son was dead by suicide. Her patient is dead by suicide. And she's a mental health professional. She's trying to link them. There's no real link, but she's trying to link them. Why? Why is she trying to link them? Who knows? We know. We know because Kay has absolutely no problems trying to, slander and defame people with whatever she can, but she tries to do it in a roundabout way. She tries to do it in a roundabout way. She doesn't want to come out and say it specifically. Bork in the Night says we do. Yes, we do know why. Because she's 50 years old and her children hate her. And she's lusting after other dicks and not her husband's because her family life sucks. Defendant's assertion that plaintiff's son had died of self-harm is false. Defendant's comments about Hayes Mitchell, when juxtaposed against her false assertion that Rae Andreacchio dying from self-harm leaves a false impression that plaintiff is somehow caused or contributed to their deaths. Yes. I would certainly see that. Okay, so that's basically what it is. Now, the causes of action were defamation. So the defamation has to come with these statements about bribery and getting young people drunk. In fact, they say defendant's outrageous allegations about plaintiff in the above statement are false and defamatory. Specifically, but without limitation, plaintiff has not committed bribery, nor has she gotten people drunk, let alone young people. Plaintiff also denies intimidating and bullying people. That really doesn't matter. It's the allegations of bribery and implying minors with alcohol. Those are crimes. That would be defamatory. And then we go on. False light, invasion of privacy. Which doesn't really matter for this, but let's see. Defendant gave publicity to matters concerning plaintiff that placed plaintiff before the public in a false light. That would be highly objectionable to a reasonable person. I don't really think you had that, but I definitely think there was bribery or there was defamation. Yeah, there was bribery. Please don't sue me. I think there was defamation. 100% I think there was defamation. So The request was for $10 million. We need to make that very clear. Now, she did file an answer. Oops, should not have scrolled up. Oops. Anyways, so her answer, and it's kind of hard to read this because it's so small. She'll like use like 10-point font or 8-point font or some shit like that. So she objects to jurisdiction, saying that there's no jurisdiction, preliminary petition to the court, requests the court to dismiss it because it's frivolous, vexatious, and vexatious. The plaintiff is a public figure. The defendant hereby submits that by virtue of her deliberate and relentless public actions and statements since the death of her son, plaintiff has established herself as a public figure cannot be defamed in the absence of malice on behalf of the defendant, which is a fair point. I would argue that, yes, she would be a limited purpose public figure for this because she has pushed for, all this. She has filed lawsuits. She has tried to get an assistant district attorney removed because she thinks he bungled the case. She's gone out of her way to make herself a public figure, in my honest opinion, throughout all of this. Gilda says, so there I was, wondering why Nostalgia Critic wasn't making any new content, and then remember he's dead. Wait, he died? Doug Walker died? I don't remember Doug Walker dying. I remember the sexual deviant who was working for him died. But yeah. So continues the defendant hereby refutes the allegation, the complaint that she held any malice towards plaintiff prior to the statement she made that is the subject of the complaint. The defendant has never met or spoken with the plaintiff on any occasion prior to her statements about the plaintiff that are the subject of this complaint, and has had no cause to feel malicious toward her other than being a twat, right? Other than being a fucking cunt, because that's what Kay does. She's a cunt. The defendant merely repeated public allegations made by others against the plaintiff, which have been irrefutably evidenced and documented in the public domain by victims of the plaintiff's pattern of bullying, cajoling, threatening, harassment, and abuse, who include a wide assortment of people, private citizens, the police, members of the Justice Department, and officials of the city of Meridian. I don't think any of that was actually documented or irrefutably evidenced. I think it's all hearsay and gossip. And again, 50-year-old wine mom with no family life. Her kids hate her. Her kids are disowning her as a mother. Her husband is probably fucking other people and she can't fuck anybody. I didn't mean to pull that up. But point is it's all gossip shit and she loves gossip. Let's see. Far from being reckless as to the facts of the situation, the defendant merely repeated the well-established facts of the situation, except they're not really well-established, at least not that I've seen. You never made the case for it. You never did. That's kind of why you have a default against you. So damage to reputation, plaintiff through a relentless and willful pattern of bullying, control, blah, blah, blah. Third, and through the incitement of third parties to bully, blah, 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 has established a public reputation as a bad actor that has not been materially affected by any statements made by the defendant that are the subject of this complaint. It should be noted. It should be noted right now. Kay said she was in possession of evidence that would prove once and for all that it was a suicide. In that, I believe, God, I can't remember exactly what was said. Son of a fuck. I can't remember exactly where it was posted, but they did go over the Let me see this. I ain't downloading that. Holy shit. Declaration of Linda Kingsland, 296 pages. What in the good goddamn? Okay, let me see. Uh, nope, that's not it. Son of a bitch. Trying to find this shit is really difficult. Okay, there's the memorandum. All right. Billable pages 200 or 27. I ain't going through that. Okay, anyways, she said something along the lines of I have evidence that'll blow the lid off this case and whatnot. And, it was a source of contention for Rae because she says that if Kay actually had this, then it wouldn't be defamatory, right? And she wants to see this evidence. And then Kay comes back and goes, I don't actually have anything. I'm not in possession of anything secret, even though I said I was. What? Critical is a moron? Yes, she is, Earth. She is a fucking idiot. And that's why she lost the case. Anyways, the defendant hereby refuses she has caused the plaintiff any emotional damage, bullying, intimidation, lying. The complaint alleges that the defendant has accused her of bullying. The defendant hereby asserts that the plaintiff has established a clearly defined pattern of bullying others in a most egregious manner, as fully evidenced and documented in the public domain. You kind of want to include that if you can prove it. And she never does. She just says it's all found in the public domain. Go fucking find it. Really, bitch? Really? Oh, by the way, this actually made me. So we're gonna come back here really quick. So one of the things that she says, it's really hard to see it. I understand that because it's so small, but she actually says right here, plaintiffs repeatedly made it known that both the defendant and her affiliates that this is not for the purpose of seeking monetary relief premised on any sincere allegation of defamation or false light. Recently, plaintiff appeared on the below referenced and linked podcast stating that she has never even heard of defendant's podcast. Plaintiff further asserts defendant was, quote, paid to say whatever that group of people wanted her to say, end quote. Defendant declares under the penalty of perjury this is unequivocally false, and she has never accepted payment in any form to make any statements regarding the case of the death of Christian Andreacchio. Defendant declares once more she relied on a FOIA law enforcement file released by the Mississippi Attorney General's office, the release of which inspired plaintiff to file a lawsuit against Marvin Sanders, employee of the Mississippi AGO, as well as against Frank Wagner for requesting the file. She continues because this is where it's really, really, really small because she just didn't give a shit. She apparently couldn't figure out how to fix all of this with Word. Anyways, plaintiff states to the podcast host, quote, I never listened to anything of hers, but I think he, meaning Dylan Swearingen, may have been on there more than one time, end quote. Plaintiff additionally makes numerous false statements regarding defendant's intent and conduct on her production. How can she know this when she admits she has never even listened or heard the content of defendant's production? Defendant once again stipulates she is no longer in possession. That's not how stipulate works. Defendant once again stipulates that she is no longer in possession of the referenced content. It would request this court require plaintiff and her attorney to provide this content so that she may continue to defend herself in this matter to the degree in which she is able to. Now, the question is she saying she's no longer in possession of this podcast that she literally links to? I don't know. Or is she saying, I don't have possession of the referenced stream that I did with Dylan Swearingen because my account was banned? I'm going to err more on the latter rather than the former, but it's not up to the plaintiff at that point, right? I guess it would be up to the plaintiff to get a copy of that, but they would have to do that through YouTube, it would be easier if Kay did it, but she probably wouldn't do it because she wouldn't want to help them win, even though she helped them win. So if she's saying that she doesn't have the podcast where Rae Andreacchio said this, she literally links to it. And at that point, it's not up to the plaintiff to provide it. You're literally the one who links it. Okay? Let's see what else. So, don't know what's going on there. She's just a mess. She really is. The complaint alleges that the defendant is accused her of intimidating or attempting to intimidate others. The defendant hereby asserts that the plaintiff has established a clearly defined pattern of attempts to intimidate others. The complaint alleges that the defendant has accused her of lying. The defendant hereby asserts that the plaintiff has lied in official statements as fully evidenced and documented in the public domain. Again, you kind of want to provide this, but provide some evidence other than going, it's in the public domain, go fucking find it, Your Honor. Probably not the best way to do it. Bribery and intent to get others drunk, including a minor. The defendant asserts that the plaintiff's wish to bribe and get a minor drunk in order to further her ill-advised agenda is fully evidenced and documented in the public domain. Where in the public domain? Where? Never answers that fucking question. Where is it? You want to provide it there, killer? You want to provide it? I don't know. Also, there we go. So, where the fuck is the evidence? The defendant asserts that the plaintiff's wish to bribing. Oh, excuse me, I just read that. Hayes Mitchell and Christian Andreacchio. The complaint asserts that the defendant insinuated after that the death of Hayes Mitchell from a drug overdose was the result of medical malpractice on behalf of the plaintiff in her capacity as a nurse practitioner practicing in the mental health field. Is she a nurse practitioner? Because that would throw everything for a loop, and that would mean that yes, she can actually prescribe medication. But I'm pretty sure she's a therapist, isn't she? I could have sworn she was a therapist. Huh. I don't know. I thought I had read in a filing by Rae that she was a therapist, not a whatever. Doesn't matter. If she's a nurse practitioner, she can prescribe some medications. If she's not, then she can't. The plaintiff has been the subject of numerous complaints of breaching patient confidentiality. How many of those complaints have been verified and acted upon? Because you can have complaints filed against you left, right, and center. Doesn't mean that it amounts to anything unless it's actually acted upon because there was actually a breach of confidentiality. Doesn't matter. She also breached patient confidentiality in the case of Hayes Mitchell by divulging what she alleged Hayes Mitchell told her while under her treatment and care. When? The plaintiff therefore grossly mistreated and harassed Hayes Mitchell and several others of her patients by breaching the rights of patient confidentiality. In the case of Hayes Mitchell, the plaintiff has even litigated against his estate after his tragic death on the basis of the aforesaid breach of patient confidentiality. What was the result of that? The public may draw whatever conclusions it deems appropriate from the plaintiff's established pattern of abusing the rights of patients and from a broader pattern of abusing her enemies. The defendant expressly hereby denies that she stated or insinuated that the plaintiff was responsible for the death of her son, Christian Andreacchio. Well, you may not have, but you definitely drew the comparison that, well, they were both her patient and they both committed suicide. And, well, gosh darn, that's a weird pattern. Indeed, she expressly stated that Christian Andreacchio died by his own hand, which was not a false light statement of personal opinion as alleged in the complaint, but a matter of public record as a determination of the relevant authority in the matter. So, that was her response. This was the motion to dismiss. And again, there we go. where she alleges that there is a lack of personal jurisdiction. And that's it. That's all she alleges, personal jurisdiction. Didn't assert, 12b6, failure to state a claim. She just said, no personal jurisdiction, ladies and gentlemen. That's it. Okay. This was denied. However, the judge did leave open, or the magistrate rather, left open that if she can prove later on that it's the improper jurisdiction, she can renew her objection and file and renew the motion to dismiss with that new evidence, which she didn't do. She just filed the exact same thing 2 more times and then complained that the court hadn't made a decision on it. By the way, that was what the March 20th, I think it was March 20th hearing was about. These things. I don't care if you restream it. I honestly don't even remember what you're talking about, Earth. So, anyways, that's what the March 20th hearing was about. It was the outstanding, right? These outstanding motions. There were 3 of them that I can recall off the top of my head. Motion for summary judgment filed by Karen, motion to dismiss filed by Karen, and filed by Rae, motion for default judgment against Karen. So, what happens on the 20th? Remember that she had just had a $900 sanction entered against her for not showing up to the previous hearing in October, and basically thumbing her nose at the court and saying she wasn't going to show up to begin with. So you get all that happening. She gets a $900 sanction on top of the $100 sanction previously. So she's 2 for 2. And then she doesn't show up to this one. Now she's 3 for 3. She's not going to show up. The court's looking at it and going, you know what? We're done here. And so they granted the default. And this actually came out quicker than I expected. Now, I want to say, after the second time she didn't show up, I said I don't see them giving them the default, because that's when they filed for the default, was after the second time. I said I don't see it happening. Unlike, the Alex Jones case, courts kind of like to give the defendant a chance to make their case. But if she missed the March one, they're going to give the default, I think. That's roughly what I said. I'm pretty sure they're going to give the default. I was right again. I was right, and I am not apologetic for it. Karen, you made your bed. So, before the court is plaintiff Rae Andreacchio's motion for default judgment. Docket 45. Upon review, the motion will be granted. It is incredibly rare for a court, before any discovery has been done, or at least discovery is completed, to grant the plaintiff's motion for default. That's how much Karen fucked up, that the court is granting it, because Karen doesn't care. Karen is telling the court, fuck off. And the court's like, fuck me? Nah, bitch, fuck you. Factual and procedural history. Plaintiff Rae Andreacchio is the mother of Christian Andreacchio, a young man who allegedly, quote, died under suspicious circumstances, end quote, in 2014. She resides in Mississippi, where she is a mental health service provider. Defendant Karen Yax is a, quote, prominent social media figure, end quote, known to her followers as the Critical K. She operates a webcast where she discusses real crime stories. She is a resident of Michigan. On March 21st and April 11, 2021, Yax discussed Christian Andreacchio's death on her webcast. Yax stated that Rae Andreacchio has, quote, really dominated the narrative about this case via intimidation, bullying, outright lies, bribery, getting people drunk, and getting young people drunk, end quote, among other claims. Yax also stated, quote, I really do believe that Hayes Mitchell, a different patient, was treated by Rae, and Hayes is now dead with a drug overdose. He's dead also by self-harm. So she has a son that is dead by self-harm, and she has a patient who is dead by self-harm, end quote. Andreacchio contends that these statements leave the false impression that she has somehow caused or contributed to their deaths. Andreacchio adds that these statements have defamed or painted her in a false light, thereby causing her to suffer injury to her reputation and or emotional damage. I wish I had that video queued up, but we shouldn't make light of this. Fuck that, we are. No, we're not. We're not going to do it. Accordingly, she filed this suit against Yax on June 4, 2021, alleging defamation and false light invasion of privacy. Yax filed her response on June 24th, 2021, in which she asserted that this court lacks personal jurisdiction over her. Yax then filed a motion to dismiss on August 12th, which this court subsequently denied November 19th, 2021. On November 30th, the magistrate judge assigned to this case scheduled a telephonic case management conference for December 14th, 2021. Court staff mailed and emailed notice of the hearing to Yax. After issuing, on December 14th, however, Yax failed to dial into the conference. After issuing an order to show cause, the magistrate judge sanctioned Yax $100. Yax timely paid the sanction. Discovery commenced. Okay, so discovery did start. I don't believe it was completed. In August 2022, Yax moved to have a fast-approaching settlement conference conducted by telephone or video. The magistrate judge denied the request but postponed the settlement conference to allow Yax additional time to make travel arrangements. The magistrate judge further ordered the parties to confer and select mutually agreeable dates to hold the conference in person. Andreacchio says Yax, quote, refused to comply with the court's order to confer and pick a date for the settlement conference, end quote. And they did file a motion, or they at least emailed the judge to say, hey, we have tried to work with her and she's being a twat. So we can't. Here are the dates I'm available. Pick whichever one you think you like, Your Honor. And the judge picked the last one available in order to give her the benefit of the doubt, to give her, something, right? We're not just going to beat the crap out of you, Karen. We're going to give you a little bit. On September 1st, the magistrate judge scheduled a settlement conference for October 18th. Yax was directed to appear in person. A text-only order dated October 14th repeated this instruction. Yax, however, failed to appear. Andreacchio subsequently moved for sanctions pursuant to Rule 16F for Yax's failure to attend the settlement conference and filed the present motion for default judgment under Rule 16F and 37B(a)(6). In her brief seeking default judgment, Andreacchio notes 3 instances in which Yax disobeyed the court's order. 1, the failure to dial into the case management conference. 2, the failure to confer with plaintiff's counsel regarding settlement conference dates. And 3, the failure to attend the in-person settlement conference. Andreacchio argues that Yax's failure to appear was deliberate, as Yax has apparently sent the magistrate judge a September 1st, 2022 email explaining that Yax was unprepared to validate long-arm jurisdiction by traveling to the state of Mississippi and subjecting myself to a process I am woefully ill-equipped to defend myself against. This bogus suit designed to harass, intimidate, and terrify me. Andreacchio adds that on October 18, 2022 at 10:28 a.m., mere minutes before the magistrate judge was set to begin the settlement conference, Yax texted a third party the following. And this apparently comes from Telegram, I believe. I don't know. I don't use Telegram. I'm not familiar with the background here. It looks like it's on a phone. So I'm assuming it's Telegram. But Critical Case says, the court threatened to sanction me again. Gives a shrugging emoji. Last time they sanctioned me $100. Who knows what they will do this time? But I'm not going there ever. It's just not even possible. So she was gloating about how she wasn't ever going to fucking show up. How's it going, Coffee? For these reasons, Andreacchio seeks a default judgment under Rules 16 and 37. In a response brief opposing sanctions, Yax argues that her absence from the settlement conference was due to economic constraints, lack of access to reasonable legal counsel, and a legitimate fear for her physical safety, mental health, and well-being. That should be bracketed. The her should be bracketed because I don't believe she actually said her. I believe she said my, not her. In reply, Andreacchio contends that Yax's poverty is very much in doubt, observing that Yax mailed her original motion to dismiss from Honolulu, Hawaii. And she did. She mailed it from Hawaii. On February 1st, the undersigned scheduled a motions hearing for March 20, 2023. The scheduling order specifically noted that the following: the defendant is reassured that she will not waive her personal jurisdiction defense merely by appearing for a hearing in this case. She has already preserved her jurisdictional defense for further review. On March 10th, the magistrate granted Andreacchio's motion for Rule 16F sanctions in the amount of $895.67. The sum is due to the clerk of court on or before May 1st, 2023. Who thinks she's going to pay? Anybody think that she's going to pay? I don't think she's going to pay it. On March 20th, Yax did not appear at the motions hearing before the undersigned. The court denied Yax's outstanding motions as abandoned and pledged to rule on the outstanding motion for default judgment in due course. And it was literally under a month. One day, under a month. This came out on the 19th. Applicable law. Rule 16F states that a court may impose sanctions, including those authorized by Rule 37B2A227, if a party or its attorney fails to appear at a scheduling or other pretrial conference or fails to obey a scheduling or other pretrial order. Great. My nightlight just started kicking in. Great. The rules of civil procedure, 16F1A and 16F1C. Rule 37B2A6. In turn, allows a court to, quote, render a default judgment against the disobedient party, end quote. Cases discuss the standard for default judgment as a sanction in different ways. In the Rule 37 context, quote, where a district court awards default judgment as a discovery sanction, two criteria must be met. First, the penalized party's discovery violation must be willful. Also, the drastic measure is only to be employed where a lesser sanction would not substantially achieve the desired deterrent effect. The reviewing court may also consider whether the discovery violation prejudiced the opposing party's preparation for trial and whether the client was blameless in the violation. Something to keep in mind for Alex Jones. Default judgment is, quote, a litigation-ending sanction, end quote. And under the litigation-ending sanction line of cases, the Fifth Circuit has reframed the standard for default judgments into one with four, requiring findings that, quote, 1, the discovery violation was committed willfully or in bad faith. 2, the client rather than counsel is responsible for the violation, meaning that K is responsible for the violation and not her attorney. And since she's pro se, she has no attorney, so she is responsible. 3, the violation substantially prejudiced the opposing party. And 4, a lesser sanction would not substantially achieve the desired deterrent effect. Because default judgment is an extraordinary penalty, the court will utilize the latter articulation as it represents a more difficult legal standard. So they decided to handicap the plaintiff by going with a more difficult legal standard, which is great because if you can get over the difficult legal standard, there's no reason to complain about the easier one, is there? Discussion. In this case, the plaintiff has demonstrated all four elements of the applicable legal standard. First, Yax has repeatedly violated court orders by failing to participate in telephonic and in-person hearings. Remember, the first hearing was via Zoom or telephonic. She didn't show up to that. The second was in person. She wanted to be able to call in via Zoom. The court refused because, again, she didn't show up to the previous Zoom meeting. Why do we have any belief you'll show up to this one? You're going to come in person. If she'd shown up to that one, the court may have been willing to give her a foot of rope and say, for the one on March 20th, you can show up for Zoom. You can show up and do the Zoom meeting. That will be fine. But she didn't. So the March 30th one, guess what? She had to show up in person as well, and she didn't. These violations have been knowing and willful. Affirming finding of willfulness in default judgment case where sanctioned party repeatedly failed to appear before the district court. So this case, Securities and Exchange Commission, the First Financial Group of Texas. The 1981 case. Although she acknowledges in her filings that her presence would be beneficial to the court adjudicating this unfortunate matter, she has texted a third party explaining that she will not come to Mississippi for the case ever. Despite the undersigned's order reassuring Yax that she would not forfeit her personal jurisdiction defense by appearing for a motions hearing, she failed to attend that too. And while Yax protested she lacks funding to participate in this litigation, the excuse only goes so far, since she could have participated in the telephonic case management conference without incurring any cost. Again, going back to the first one, you wouldn't have had any costs associated with this if you had called into the first one. It's a case of we gave you an out. We gave you the benefit of the doubt in the first one. You took our kindness for weakness. Well, guess what now, motherfucker? You're no longer getting kindness. You have to earn that. Second, because Yax is proceeding pro se, there is no question that she, and not an attorney, is solely responsible for her conduct. Next, there is ample record evidence that Yax's failures to appear prejudiced the opposing party. Every time the plaintiff and attorney travel to Jackson for a hearing, they incur nearly $900 in expenses. When she plays this game of Lucy and the football, therefore, Yax is running up her opponent's bill. This is the definition of prejudice. See United States versus McCullen, Fifth Circuit, 2022, finding prejudicial, quote, the resources and the plaintiff had to expend to respond to the defendant's numerous rambling filings, end quote. You know, kind of what they've had to do with Karen's filings. Lastly, a lesser sanction would not substantially achieve Yax's participation in this lawsuit. Warnings and show cause orders have borne no fruit. If Yax lacks resources, a third award of monetary sanctions would be pointless. Incarceration, meanwhile, would likely be too severe a sanction. How are you even going to get her incarcerated in Mississippi when she lives in Michigan? Mississippi's not going to want to pay for the extradition issue. So that's not going to happen. Given this record, it is unclear what lesser sanctions could have been appropriate following the district court's warnings and second chances in Taxotere production liability litigation, and that's a 2020 citation. For these reasons, and on this record, the rare sanction default judgment is warranted. Conclusion. Andreacchio's motion for default judgment is granted. An evidentiary hearing is necessary to determine an appropriate amount of damages. One will be scheduled shortly. Yax is invited to participate. So ordered, 19th day of April, 2023. There you go. There is the decision, ladies and gentlemen, to grant the default judgment against Karen Yax, the critical K. Because K decided to ignore the court. K decided to tell the court to fuck off. Bad call. Now, what is K going to do? Well, Poopnock says, great, now show damages. Well, that's what the hearing in May is going to be. It's about showing the damages. So my belief, they've asked for $10 million. I don't think they're going to get anywhere around that. I think the most likely scenario is probably going to be between $75,000 and $200,000. I will say the absolute top, I think, will be $1 million. I don't think they'll get that. I think it's going to be closer to $75,000 to $200,000. I just don't see it going into seven figures. I would be surprised. I wouldn't be surprised. I find it highly unlikely it'll go into six figures. I would be very surprised if it entered seven figures. Non-zero chance it's $1. It could be $1. That is true, Poopnock. It could be a $1 damages. But that's still damages. Now, what is Kay going to do? Well, let's bring my ugly mug up. Scuttlebutt right now is that Kay is going to file for bankruptcy. I've heard this from a couple of people. Kay was talking about filing for bankruptcy if and when the court found against her. Won't work. or at least not likely to work. Uh, what is Chapter 7K's living situation? Is she broke and living in Section 8? No. Um, Kay is married. Her husband appears to be a Ford employee, um, working in a factory. So he's under like the AFL-CIO or whatever the fuck. I don't know, but he's in a union, collective bargaining and shit like that. I don't think they're going to be able to. Can she do that if she's married though? Probably not. Probably not. That's a good question. I don't know, but she's talked about filing for bankruptcy, which she thinks will uh, get rid of the judgments. And the Fifth Circuit, it will not. And Louisiana, or excuse me, Mississippi is in the Fifth Circuit of the federal district. They do have case law that states intentional torts, such as defamation, which is what this case is, cannot be discharged by a bankruptcy. You intentionally committed these torts. You can't go, oh, well, I want to make a culpa, I want to fuck up my credit for the next 7 years. I'll just declare bankruptcy and get out of this, this judgment. Doesn't work. Now, Michigan is not in the fifth district. I can't remember exactly. Where is Michigan? Michigan. I think it's the seventh. Sixth Circuit. So she's in the Sixth Circuit. So the question is, with the Sixth Circuit, would the Sixth Circuit authorize, or would it allow for the Fifth Circuit decision that prevents discharge via bankruptcy? Would the Sixth Circuit grant that? Would it go, oh yeah, that's fair? I think they would. And the reason for it is, well, this was filed and she willfully decided not to be part of it. She decided not to be part of it. This isn't the court fucking with her. She's the one who decided, I'm not going to be part of this case. I'm not going to take part. Court's going to look at that and be like, you brought this on yourself, bitch. So I think, somebody said 60-40. I think it's going to be 70-30. I think it's going to weigh heavily on the courts are going to come down and say, no, you can't discharge this in bankruptcy. And as soon as that, I just want to say this, as soon as that order comes down, granting damages, Rae has already said in a previous email through her attorney to Kay, she will have the judgment. I can't remember the exact words, but basically it's going to be, she's going to have the judgment validated in Michigan in the Sixth Circuit, and she's going to go after her for every penny that she's owed. So I don't know. I wonder if they'll have to refi the house. I don't know. Okay, so how does she file bankruptcy if their assets are considered joint as married? I don't know, point to a prenup or some shit. I don't know. I look, I don't have to deal with it. So I couldn't fucking tell you. So yeah, there you go. Kay has been thoroughly. I have heard tell that she is crying about it, to her patrons, to her Patreon supporters and whatnot, because boo hoo, she's a fucking victim. Boo hoo, guys, she's a fucking victim. No, you ain't, bitch. You ain't a fucking victim. You brought this on yourself. I think she's trying to. Crowdfund people to pay off any damages that might be owed. She's not going to get. I don't think hubby's going to want his credit fucked up too, just because she doesn't want to pay a judgment. Yeah, but of course, it's to the point where if he tries to divorce her, he's probably going to have to end up paying the judgment anyways, because Michigan, and the man is fucked in that situation. I don't know. I don't know. It's very funny because I pretty much called the sanctions that were going to come down the hill, or at least I called that they weren't going to give the default after the second one, and that they would probably do it after the third. Uh, I've kind of called it the entire time, and it's amazing how that works out, ladies and gentlemen. It's amazing how that works out. Kay, if you just hadn't been a twat to everybody, if you had just if you had just done what was required, you wouldn't be in this situation, right? But Michigan, can he claim trans status, get custody of the kids, and put all the judgment debt on Kay? Probably not. If the court actually gave a shit about the kids, I'm gonna angle this down just a little bit. If the court actually gave a shit about the kids, they would see how much of a piece of shit mother she is, what she's doing online, this judgment, and give him full custody of the kids to begin with. I'm just saying. I'm just saying. Could do that, but they won't because, again, Michigan. What is worse, divorce and he has to take on part of the judgment, or not divorce and he has to live with her? Ooh. The part of me, I think having to live with her is the more painful of those two. I think that's the one that I would be more fearful of. Money is transitory, right? Money is transitory. You pay it off and there you go. And he's got a good job, so he probably could take care of it. I don't think the court would saddle him with it. I mean, he has to pay the judgment either way. That is true. That is very, very true. He's gonna have to pay it anyways. I don't know. I don't know which one is going to be worse. I just find the entire thing funny because, you know, she goes after Alyssa for being a terrible mother, according to her, and she's got a kid who disowned her. It has nothing to do with her. Her oldest child. I couldn't imagine doing that to my mother. My mother, you know, my mother's a good mother. Love her to death. I couldn't imagine a mother who just doesn't give a shit. I can't. I'm sorry. I can't. I can't imagine a mother who would try to ruin your relationship by creating fake Facebook profiles and starting drama because she doesn't like her. I don't see it. I can't see it. This is what I mean by she's a fucking wine mom. God, I hate bitches like this. I really do. Like, talking about this is fine, right? Talking about drama is fine. Going out and causing the drama, it's like high school shit. It's so stupid. It really is. So I only had to drink one Guinness today. To get through that, I only had to do one. Not bad. So that's going to be it for the stream. It did not go too long, which, was a small decision. I think we'll see a larger stream after the evidentiary hearing. I'm going to get in touch with Matt. I know. Well, I had called Matt, the attorney for Rae, after the March 20th hearing. That's actually how I found out about the her not showing up. He was like, "Oh yeah, she didn't show up." I was like, "Oh, fuck." Right? And he's like, "Yeah, this is gonna be something on Pacer. It'll be fine." Um, maybe I'll try and get him on. Maybe I'll try and get him on. But he is like, "Are you the Spectre report?" So that was really cool. He apparently knows my stuff, which Matt, why do you hate yourself that much? Critical K's finances hoped it was worth it. These bitches love saying stupid shit. They love slandering. They love defaming people. They think they have a pussy pass, and then all of a sudden, well, if it isn't the consequences of my own fucking actions. So, all right. So I'm going to call the stream here, guys. Thank you for tuning in. This isn't the end just yet of the Critical Case saga. We still have the evidentiary hearing, and if she appeals, which she might appeal. Then I will also cover that. So you guys, it's been a fun stream. It's been very interesting to see how this is played out. Really shows you just how much of a coward bullies online tend to be when shit comes into real life and they have to deal with it, and they're not the ones they're not the ones really on the strong end. They then cry about being victims, and it's interesting to see. It really is. I dish it out. I can take it. That's why I don't claim victimhood or something. I do something stupid. I did something stupid. I take my lumps. It's weird how other people can't do that. So you guys enjoy it. Enjoy your weekend. Sunday I might do a bit of streaming on Rumble. I don't know. The last couple of weeks I've been kind of sick. I actually ended up stepping on a nail. The wound became infected last week, so I've been off and on the past 2 weeks. So I don't know if I'll stream on Sunday. I'm gonna try to get Wyatt to play some DDO again. And we'll do 7 days a night. I haven't played that in a while, but you guys enjoy it. Enjoy the rest of your weekend. It's almost Saturday. It is Friday night, so enjoy the evening, everybody. I'm Spectre. Thanks for watching.